International law is the set of rules, agreements, and treaties that are binding between states. When sovereign states enter into agreements that are binding and enforceable, is called international law or international legal system. It is horizontal in nature because all states are equal in nature. International laws promote peace, justice, common interests, and trade. International laws apply to governments. It's up to each state and government to implement and follow international laws. A country's laws apply to citizens and other people that are present in the country. However, it's up to the country's governing authority to apply international law and keep their agreements with the other countries that are involved. Therefore, domestic legal system is said to be vertical in nature because it's the state machinery that governs the individuals. What comes to your mind when you think of international law? It is simply the set of rules, agreements, and treaties that are binding between countries when sovereign states enter into agreements that are binding and enforceable. It's called international or international legal system. It is horizontal in nature because all states are equal in nature. This means that the law applies to all nations equally. So what are the functions of international law? International law promotes peace, justice, common interests, and trade. International law generally comes from 5 sources given in the Article 38 of the ICJ statute: treaties, customs, general principle of law, judicial decisions of ICJ, and academic writings. Treaties are express agreements that countries enter into voluntarily. They're written agreements. They are considered a more modern and deliberate method of law creation. There are many writers who feel that treaties are most important source of international law, as the express consent of the state must be taken before it is applied. The entire system of international law is based on consent. The Vienna Convention on the Law of Treaties of 1969 calls for interpretation of treaties based on the plain language of the words in the treaties. The context of the words and the presumption of good faith and good intentions can also play a role in interpreting a treaty. Customs are common practices between countries. They are common practices that are so expected and consistent that countries operate with the belief that custom is legally required and binding. Examples of customary law are the prohibitions of a state using or condoning genocide or slavery. Generally, as long as a state doesn't object to a customary law, it applies to that state. General principles of law are rules of law that develop over the time. Principles of law are an understanding of how the law should work based on past rulings. In addition to looking at past rulings, international courts can also look to judicial opinions for help identifying and interpreting international law. The judicial decisions of ICJ are also a source of law, though it is subsidiary in nature. The General Assembly of UN, the United Nations, has the right to ask an advisory opinion from the ICJ. Therefore, court is quite authoritative as far as lawmaking and the status of the law is concerned. Finally, the writings of international academics are also considered subsidiary source of international law, as they have direct impact on customary international law. Until recently, international law took no notice of individuals. It used to be a system that only operates between states and governs its interstate relationship. It was generally unconcerned with what states inside its boundaries. The idea of human rights emerged stronger after World War II. Governments then committed themselves to establishing the United Nations with the primary goal of maintaining international peace and security. People wanted to ensure that never again would anyone be unjustly denied life, freedom, food, shelter, and nationality. Member states of the United Nations pledged to promote respect for the human rights of all. To advance this goal, the United Nations established a Commission on Human Rights and charged it with the task of drafting a document spelling out the meaning of the fundamental rights and freedoms proclaimed in the Charter. The Commission, guided by Eleanor Roosevelt's forceful leadership, captured the world's attention. On December 10, 1948, the Universal Declaration of Human Rights was adopted by the 56 members of the United Nations. With the goal of establishing mechanisms for enforcing the UDHR, the UN Commission on Human Rights proceeded to draft 2 treaties. the International Covenant on Civil and Political Rights and its optional protocol, and International Covenant on Economic, Social, and Cultural Rights. Together with the Universal Declaration, they are commonly referred to as the International Bill of Human Rights. It is universal in nature and open to membership from the countries around the world. International law, as the foundation for the international protection of human rights, tends to recognize states as the holders of rights and duties, not individuals. This has influenced the development of human rights law. We cannot think of the model of domestic law. Rather, we need to appreciate that enforcement mechanisms really depend on procedures that involve a court issuing a remedy.